A call to order the meeting of the Board of Port Wardens on Tuesday, March 24th, 2026 is called to order at 7:01 p.m. In attendance, we have four Port Wardens, myself, Mr. Lerner, Mr. McCop, and Mr. Siegel. We also have Mike Beacons from the city, as well as Alderman Thorpe. And from the Harbor Master's office, we have Beth and Tyler. We also have Carrie, the city's attorney, joining us. So I just want to thank them for being in attendance. We can go ahead and probably thin it down to the port wardens and Mike, and then we'll move through the administrative tasks. Um, so first, let's get the approval of the agenda for tonight. So the next item in this, is the approval of the agenda. At this time, I'd entertain a motion to approve the agenda.
Motion to approve.
All right, thank you, Mr. Lerner. Seconded, Mr. Siegel. Thank you very much. All those in favor, please state aye or yes. Aye. All right, thank you. All four unanimous. Thanks. Motion passes. Let's go ahead to administrative. Now we have 2 minutes to approve because we had a delay in one of the minutes being finished due to vacation type thing. So the next item on the agenda is the approval of the minutes from Tuesday, January 27th, 2026. I'd entertain a motion.
I'll make the motion.
All right, Mr. Siegel, thank you very much. Can I get a second?
Second the motion.
All right, Mr. McCop, thank you very much. All right, all those in favor of approving the minutes from Tuesday, January 27th, 2026, please state aye or yes. Aye.
Aye.
All right, thanks. That's unanimous. Thank you. And then let's go to the next item on the agenda, which is approval of the minutes from Tuesday, February 24th, 2026. I'd entertain a motion, please.
I'll entertain that. I'll take that motion. Make that
Very
motion.
much. A second, Mr.
Second the
McCop.
motion.
Thank you very much. All right, all those in favor of the approval of the minutes from Tuesday, February 24th, 2026, please state aye or yes.
Aye.
Aye. All right, thanks. That's unanimous again. Thank you. All right, the next item on agenda is the findings of fact from Tuesday, February 24th, 2026. We only have one of them this evening. And it is the port 2025-00016, 32 Williams Drive. It's replacing kind 6x63 pier with 10 by 21 platform, 2 mooring piles, and 1 boat lift. Everyone can sort of read from the element. All right, is there a motion to approve the written findings of fact? Can I get a motion?
Motion.
All right, thank you, Mr. Lerner. And is there Mr. Siegel? Thank you for the second. All those in favor of the motion to approve the written findings of fact of port 2025-00016, 32 William Drive, please state aye or yes. Aye. All right, that was unanimous. So that finding of fact is accepted. Thank you. Thank you. All right. Let's go ahead and move to old business. So the next item on the agenda is port 2026-00001, 7040 Bemby Beach Road. Josh, can you bring in, I believe there are 2 parties involved in this. If you can bring them in, that would be great.
Robert, just before you get to that, I think you have to do the chair election.
I did. I apologize. Let's keep everyone muted. We can still keep their images. They can get their cameras ready. But let's go ahead. Port Wardens, we need to make a decision on chair and vice chair. I know Scott is not present. He did send that email. Let's go ahead.
I'd like to make a motion for the chairman to continue, Mr. Shapiro.
Okay. There a second?
Second.
I'll second.
Okay. All right. Thank you very much. All right. All those, I guess, Carrie, I still can do this even though it's me, or?
Yeah, you can still do it.
Yeah.
And you can vote.
Okay. All those in favor of Robert, me retaining the chair position, please state aye or yes.
Aye.
Aye. All right. Thank you very much.
You have to suffer through it again.
Okay, Scott did put in that email, he put his name in the hat. He can't make it this evening. I'll leave, it up to you guys you think we should wait till he's in attendance? Or is there anyone else interested in the vice? And even in that case, we probably should wait for him. What's the prevailing opinion? Or is there a motion?
I don't know whether we should wait for him to be here or not. You guys have thoughts?
Does anyone else have interest in being the vice chair?
If he didn't want to do it, then I would do it. What did he?
Jonathan, do you have any interest in vice chair, or I mean, not to be too direct? Sorry. And no, again, I'm not no issue with Scott either. I just want to make sure. Jared.
Go ahead, Harold.
Yeah, I think my general thought on the thing is, we're not. This isn't really a political thing or anything here. That we're just us, and I like in general the idea of perhaps at some point, rotating things around a little bit. Just kind of because we're all here, and just to rotate the chairmanship and vice chairmanship, and just from year to year moving around. But right now, Robert's doing a fantastic job, so I'd like to leave that where it is.
All right. So do we want to wait and do it when Scott's in the mix, and then that way it can? Is that what do you guys
do that, Carrie?
Just so that we're clear, you guys have already voted on chair, so it would just be vice chair. I don't necessarily see an issue with holding off on making the vote for vice chair at your next meeting.
Okay. All right, great. Thank you very much. Okay. Thank you for reminding me of that line. I did not highlight it. Let's get back to the old business, or move forward to the old business. And that's Port 2026-0001 7040 Benby Beach Road. We have the participants involved. Mr. Sari, if you could take your mute off, just because for the swear, and it's easier to do it one fell swoop. I need to hear and see your hand raised as well, just that way it's on the video and there's no confusion, or if there's a bad connection, we got two ways of confirming it. So anyone planning to testify in this particular matter or application, please raise your right hand. Okay. Mr. Sari, are you going to testify?
Yeah. Yes, but
I don't see your right hand up.
Our video is frozen for some reason.
No. Okay.
Yes, we're both myself and Mrs. and my wife.
Okay, let's do this.
Here.
All right, you do solemnly swear or affirm under the penalty of perjury that the testimony you're about to give to the Port Wardens is the whole truth and nothing but the truth.
Yes.
Yes.
Okay, great. Thank you very much. All right. As a preliminary matter, the board will accept into record the application packet, the staff report, and any public comments. Would Mr. Meekins from the city like to present any additional information about the written staff report, as well as confirm any public comments that might have come in?
I have no, thank you, Mr. Chair. I have no additions to the staff report. This case obviously was pushed from the last meeting, and since then we did receive one additional comment from actually Mr. Sari, who was in attendance tonight, and I had forwarded you the Port Wardens that comment. And that was the only comment that we received.
Okay. All right. I believe the mail scenario has occurred appropriately, right, at this point?
So I'll leave that to the applicant, Mr. Bollinger, to testify to that.
Okay.
All of the names on the list provided by Mr. Meekins were notified by mail.
Okay, great. Thank you very much. I know there was some discussion of the sign, but we had left the last meeting that I believe we all established that it was aware this was in place, and that we did just had to get that procedural part of the mail correct. Can we go ahead and have the applicant Ideally, Mr. Bollinger, actually anyone in tonight's meeting, if you could share a screen, or if you'd like me to share a screen of a particular image, that would be great. I know it's much clear, or it's easier for people to see it as we're talking about the spaces and the lateral lines and all those things. You can let me know and I can help share if you don't have that functionality down pat. You just again let me know. I've got Google Earth open, and I can also, of course, open the application. Okay.
Well, everybody has a copy of the application, I assume. Is that correct?
Any of the port wardens, yes, and the city, of course.
Okay. What I'd sent, let me just give you a little history here. There was a jetty between our property and our neighbor's property, and it was removed when he had a new bulkhead put in to his property, and the jetty was not replaced. That then served to cause erosion on our beachhead in front of our bulkhead. And it's gotten worse over the past 2 years. So what this application is for is to simply replenish the living shoreline that was there and put a jetty back in place so that the shoreline does not erode and expose our bulkhead to the water. And that's what we had designed. It will be planted with grasses as the current living shoreline in front of the property is right now. And that's what we're looking to do.
Okay. Do you have an engineer? I mean, I see there's it looks, I can't make out, at least on sheet 1 of 4.
Sheet 3 of 4 that was last sent as a site plan in February shows in detail the break wall and the planting of the sand and the living shoreline. And it shows that the stone wall will be placed 5 feet from the lateral line.
Okay, that stone groin is how they're referring to it, right?
Yes.
All right, and there isn't one existing anymore. I was looking at an image from 225. Is there one there now, or no? Did that get removed?
It was removed. There's rubble there tucked in behind the bulkhead between our two properties. The remainder of what was there.
Okay. Is this in sort of lieu of doing the bulkhead? Is there a just out of curiosity, like a lot of times that you would think you were, well, I guess you really can't use the backside of the deck. Is it too shallow? I mean, the dock, the existing pier that it is the closest one on his side. Is that too shallow back there?
I'm not clear on what you would mean by using it for what. It's navigable behind it and it's used for docking.
It is okay. So are you? But if you adding a living shoreline in addition to the bulkhead, wouldn't that push the sort of remove some of the depth by pushing it outward, or no?
Well, we're not adding a bulkhead. The bulkhead that is there remains.
Right.
And what we're doing is reestablishing the shoreline that was there originally.
Okay.
And we're not going any farther out because we don't want to lose that water and that depth and the use of the dockage behind on the backside of the finger pier.
Okay. And also, just again, I'm sorry, the image I have is fuzzy. What engineering group put this together? Bayland. Okay, thank you. It just when it's on the application of a copy of a copy of a copy, their logo looks like, but I can make it out now that you stated it. Okay. Let me go back to, all right.
Mr. Chairman, we provided the city staff with all of the pictures of the original jetty and the engineering drawings that showed the jetty in place between the two properties. And I assume Mr. Meekins can provide that information to you.
Okay.
Yeah, I did forward that information.
Yeah.
Okay.
Okay, thanks. Yeah, no. All right. So now let's go ahead. Public testimony. I assume that would be Mr. Seri.
Yes, can you hear me?
I can hear you. If there's anything you want to share, that would be great. Or like I said, if you want me to put something up, you can let me know.
Yeah, I'd sent 5 proposed exhibits to Mr. Meekins, I don't know, a little while ago, and he said he was going to forward them to you for inclusion in the record. Did he do that?
He did do that, but it would be probably it's again always nice when people present and we can see exactly what you're describing, especially if you're driving the mouse pointer. But I can certainly let me find the one you sent.
Okay, but
we have them. We have them.
Okay,
we can put them up, but
sure.
Also I just wanted to go through a couple of things prior to that.
Okay.
Before we get into the proposed exhibits. So, I mean, I do want to make note for the record on the notice, if there are people who are, interested in this issue from an environmental standpoint or whatever, they don't have notice that there's the meeting tonight. So I'm just stating that for the record in case somebody wants to appeal the decision, because there's no notice for the meeting tonight. Other than the agenda you sent out. So it's not posted on the property, it's not in the newspaper, and we received it. The notice for this hearing has to stay up during the pendency of the hearing. So 10 days before, it has to be removed within 10 days after. So there's no notice up right now for this hearing at all. So I want to state that for the record, and I don't think proper notice has been given for this particular meeting tonight. Okay, so second point that we made in our comments, and the previous comments we made changed because first of all, we had more time, and second of all, the plans changed that CRAF submitted. So, and that's another reason as far as the notice is concerned, is now the new plans actually submitted. So they're different than the previous plans. So, but the second point I had was authorization from the city for CRAF to proceed on its behalf. I don't see that city, this is city property, and the city would be the party who would be making changes to the property, particularly in the water area. So I don't see any authorization from the city specifically to do this. Okay, so do you want to just continue or do you want to respond?
I probably, we could, Carrie probably has a sense of whatever the agreement that was presented with it that is between the city and CRAB. We're not attorneys in that respect, so I'm not sure the full scope of what is allowed to be done. I mean, normally with a leaser scenario, there are some limitations, but I do not know that. I hate to throw it on Carrie, but
so I'll just jump in and say the agreement between the city and CRAB, CRAB is responsible for maintenance of the property, and this application falls under that category. Unless
Okay.
Mr. Bollinger wants to correct me on that, but that's my understanding of the lease agreement with CRAB, is that the tenant, which is CRAB in this instance, is responsible for, among other things, but maintenance of the property.
And improvements can be done as long as everything follows normal city, planning and zoning and building and all of that, correct, Carrie?
Yes, I mean, they obviously would be subject to the same legal requirements that other applicants would be subject to, including the city.
Right. Okay. Just checking.
So we can move on. Okay, so the main issue that we have is CRAB is presenting this as a restoration of a beach. And we bought the property at 7046 next door about the same time as CRAB was, the city had purchased property and CRAB was doing its development of the property. The photographs and drawings that we presented as evidence clearly show that there was no beach in the area that CRAB is now proposing to fill. And second of all, the idea that you're restoring a beach is a misnomer. I mean, I think that's misleading to the public if you're stating on a sign that this is a beach restoration project. There was never a beach there. Crab has provided no evidence that there was ever a beach there. What Crab has stated is that there was, they call it jetty. What it was, in fact, was a homemade pile of rocks and rubble that the unpermitted, MDE came and looked at it and they said it was unpermitted. We could not put it back in. Crab could propose to put something in if they wanted to, which is what I assume they're doing now. But that so-called jetty was just a pile of rubble that our contractor had to remove to get their barge in close enough. And the state of Maryland has had no issue with us removing it. The only person who's had an issue with us removing it is Mr. Bollinger. And what the problem we see with putting it back in, if you look at the pictures we will show to you, is almost all the sand buildup was on our side of that little pile of rubble, so-called jetty. So there was no beach on the other side. And let's go to the photographs now. Let's screen share. Let's see.
Real quick, Mr. Chair. Miss Bellis has her hand raised in the attendees. Do you want to bring her in? If she
Yes,
has to do that?
please.
Okay.
Yeah, I do. Thank you.
Okay, so let's go
Wait, just,
to exhibit 1.
okay. All right, hold on.
Well,
When you-
I do want, before the harbor master speaks, I'd like to let the one public testimony continue and finish, and then we'll get into, we can ask questions and things like that.
Okay,
So-
Yeah, we're trying to share the screen.
I'm working
but-
on it. Well, just give me a second. Okay, I gotta open these, so.
Okay.
Just give this- Hold on. It's loading. There
Okay.
it is.
All right, so are you able to see that?
We don't see an image, but we see exhibit 1 through 5. The folder.
Okay.
Let me just, hold on.
Technical guru is trying to.
I'm trying. I'm trying, just a second. I'm trying to get back to the Zoom, so, just a second. Let me just do this new share. Okay. All right. You should see that.
Give it a second. Okay, yes, we see an image.
Okay, so I'll just describe that photograph. That you can see the new pier gangway off in the upper left corner. You see a grass area next to that, which is the existing beach. You see water all the way up in front of our property, which is in the forefront of the picture. That picture is before Crab done anything on shore. You can see the old building in place in the center top of the screen. So that's 2021, 22 roughly. No beach there. Okay, so number 2.
Okay, hold on.
We'll share that.
Can you see it? No. Okay, hold on, wait. I have to reshare. Sorry. We're not experts either.
No worries.
At all.
If you want, I can attempt.
No, I got it. I understand how to do it now. Okay.
Okay, do you see that?
Not yet. There we do.
Okay, so that again is around the same time frame. You can see a tiny bit of Crab's new dock on the left side center of the screen. You see the original house that was there, the original building, our house and garage right on the right side of the screen. You can see beach in front of our property, which is now has a substantial bulkhead that we replaced. You see no beach in front of Crab's property until about the set of stairs. And so again, this is before Crab has done anything at the property. Again, around 2022 roughly. Okay, and I go to number 3.
Now I know how to do this. Hold on. Switching.
Okay. Let me know when you have the image. Yeah.
Okay.
All right, so that's a current screenshot from Google Maps. And that again shows now crab's entire facility. It shows the beach and the grassy area. It shows no beach to the left side of the center of the screen, and it shows Crab's Pier, and the area they're planning to fill is way out toward that pier. You know, I don't know, some distance out, but it's going to make that opening very narrow there, which, you know, is public property. So that will be more or less closed off if that was to be built out in that area.
So I wanted to just, this is Ann Nitsenson, I wanted to add something else. This photo is before we did any work on our old dock. So that pile of rubble was still there. You can probably barely see it. It was pretty small. It was a bunch of cinder blocks and some rocks that the Williams family had put there. And actually they told us that they had originally put it there, try to preserve some kind of beach in front of their property. Which when we replaced the bulkhead, you know, it didn't need that beach anymore. But this is the area that Crab is talking about filling. And this is the backside right here. I don't know if you can see the little hand moving around, but this is the backside of their pier. And they do use this. They do use this. We have seen them tie boats up here, and they do use it. So, you know, in this other piece of what you as the port wardens evaluate is, does it render navigation too close and confined? And if you're going to build a groin here and you're going to try to create a beach here, you're going to really render navigation to this part of the pier.
But that's his riparian rights area. I hear what you're saying. He's not protruding over his setback. So I hear you might have a nice concern for his. I just want to make sure that at this point that's his scenario. Okay.
Okay, right to the pier, that may be his issue, but to the shoreline, that's public property. That's available to anybody in the city can go onto that beach. So just to be able to block that off to any boat to be able to get in there, you know, in theory, probably nobody's going to go there, but to then fill an area that's otherwise deep water, that's what we're talking about. So yes, you know, not being able to access the other side of that pier obviously is going to be an issue for crab primarily, but access to the beach.
And so, it does block the other piece of it. We'll move on in a second, but the other piece of the code is that it does create an impediment to reach the harbor line from the shore of a publicly owned property, which is this property. So we'll move on from that.
So
but that picture shows that there is no beach there. There was no beach there. So now we're going to move on to Exhibit 4. Hold on, let me just share. Just a minute. Thank you for your patience on this. Here we go. Okay.
All right, let us know when you can see that.
I'm zooming in so it's a little bit easier to see. Oops. Yeah, I am.
All right.
These are Crab's own drawings.
Okay, are you able to see that?
Yes.
Okay, so this is from during the Crab's approval process for the shore-based portion of their project. And here they show a mean high water line, again, pretty much, you know, like it is now. No sign of any additional erosion. Bulkhead the full length of it. So that tiny bit of riprap you see on the left side of the corner of their property is what was removed, and that's again, obviously wasn't holding anything back. There was no beach right there, and then the beach just gradually gets a little wider as you head toward the right of the screen or in the easterly direction. So, and that's Crab's own drawings. Okay, and then number 5, we'll pull up. And this has more to do with what Crab's actually planning to do, which isn't really clear to us because the city's website says one thing and Crab's plans say another, and they're quite different. So we are really kind of like confused by what the plan is here. This is from the city's permitting and zoning website. It says material to be dredged 10, control cup depth of cut 4. Material to be deposited at site 100, dredged from shore, removed by truck, 10 cubic yards deposition from shore. So like, this is not on the plans at all. Like, is there dredging going on here? Is this filling only an area that was, never filled? so that's really on Crab to explain what that is. And then I can just go over a few more points quickly that we made on our comments. Number one being that anytime you're getting a grading permit under the law, you're required to submit an environmental assessment as part of that. We don't see that. The Maryland Shoreline Erosion Control Guidelines say, groins are last resort. So that's more or less our comments. We don't think that this beach ever existed. We think calling it a beach restoration is deceptive and incorrect. And I mean, what is, it doesn't look like a professional engineer has stamped any plans, even though it's required. Like, anybody could have done these plans. We don't know. I think Crab's representing that some company has done it, but who at the company did it? What person is responsible? For example, when Crab did its previous permitting, when we did our permitting, we had the engineer actually come and testify as to what they were doing. So we don't know who's put these plans together. It's not shown on other than some company, but they're not here representing that those are plans they created. No environmental assessment. We are really concerned that this project, the main concern for us is that this project is going to result in sand drifting out of this area in front of our property. It's already silting up quite a bit and making our dock, our brand new dock, unusable. So this is just kind of like somebody put together a plan and are presenting it as restoration, and the whole thing is misleading. So that's do you want to add anything more?
No, I think I'm
Okay. All right. Thank you. Beth, wait a second, Mr. Bollinger. We'll get some more. Beth, did you want to?
I'll be very brief. I know
Okay.
that Mr. Bollinger is at a very long lease with the city, and I know that he is a good steward. But I will also defer to Carrie Berger. But I'm a little concerned if administration doesn't know, and we can't any of us imagine what the city may do with this property if Crab ever leaves. And so my concern is that, is there a written permission for this change, given that just because we get a permit, like, I don't know if the administration knows, and like, that's my concern. And I would defer to Carrie. She might think I'm out of order. She might have some more to add to that, but that's my thought.
I certainly haven't alerted the administration because it's not my responsibility. I would assume that probably through planning and zoning and Mr. Meekins that notification would be made, or through Mr. Bollinger himself. And I can't answer whether or not the administration knows, but I generally would agree with the sentiment that they should be made aware if they're not already.
I mean, certainly the lease requires written permission. So that would just be, I would just want them to know and be good with it. That's all.
We will get to rebuttal, so just bear with me a second, because I sort of have a question from Carrie, and we probably should have done it in the beginning. The posting issue with the signage, what is, I mean, what is your opinion of that? I do believe I looked at the minutes, and we did leave it with, you should be fine just making sure the mail is accurate. But
So the last meeting, that was the only question that was presented to me.
Okay.
Anytime that there's a hearing, or even if it's postponed, I would have to double check the code, but the notice requirements need to be made regardless. And so the question that was posed to me at the last meeting was, is there another, does another notice via mail have to be sent out? Or is the fact that we're all here tonight sufficient notice? And I said, no, you have to send out the mailings again because it's a new hearing. The whole matter got postponed to tonight. So if there are other notice questions, implications, I was not asked of them at the last meeting, and I don't know what the circumstances surrounding those are, so I can't really opine one way or another. But the
Okay.
expectation is that the code will be followed at all times.
All right.
Robert, I kind of add to that. I looked up Title 15 for this, and the signage says the sign has to be posted 10 days before the meeting and has to stay up until 10 days after the meeting.
Okay.
And that's signage on the property.
Okay. And the signage, Mike, I'm not trying to throw anybody. The signage comes from the city, right?
Correct. The signage comes from the city, two signs, waterfront and readable or legible from the right of way. And those signs were given to the applicant and they were posted 10 days prior to the February 24th meeting.
Okay, but not this March meeting.
Correct.
Um, Carrie, we certainly don't. I wanted to work out. When I say work out, our job is to try to figure out, how and where it's right to say yes, but we also have to follow sort of standard procedural elements. Mr. Bollinger, I apologize if it was on us that actually, didn't happen, but we obviously can't make it easily and blatantly appealable if it doesn't, sort of get posted. If there are other neighbors that were unaware that this got postponed without those postings, I granted they did receive the mail that you sent, then I'm wondering, I hate to do this, I really truly do, but we might have to push this.
No, I don't really, I find that offensive, Mr. Chairman. This is a situation where Crab did exactly what the city said. We made the mailing and the notice to everyone. We have followed every instruction given to us by the city. We have a neighbor who is trying to stop us creating a living shoreline at the property, and their king tide pictures that they have. I can show you the pictures where the beach actually goes all the way across with the jetty there. So as you stated well previously, this is our property to maintain and to follow procedures, which is getting a Board of Port Wardens approval. We've already met and discussed it with the Maryland Department of Environment. This project is already approved that it will get a living shoreline grant. So we are lined up.
Is the MDE submitted, may I ask?
I'm sorry?
Is the permit with the MDE? Don't you have to have a?
No, we cannot submit it till we have a permit from the Board of Port Wardens. So we're waiting for this number and then we were going to submit it. So we have absolutely done everything. This is our property owned by the city. We're protecting it, and now we're getting denigrated for protecting it.
Mr. Bollinger, is the signage, is it up on the property as we speak?
No, it's not, because it has the incorrect date.
So as counsel to the Port Wardens, I would advise you, if we have not met the notice requirements, that being the Port Wardens, that we should not be issuing a decision tonight because it is appealable and we will lose on appeal, which will prolong the project.
Okay.
Should it be granted. So
Thanks.
Robert,
Yes.
I'm getting a deja vu. This is exactly what we talked about a month ago. We postponed this exactly for this reason.
No, it was because of the mail notification.
The mail and the
So
sign.
it was procedural, but it wasn't the signage. And that was part of and that's why I do sort of trust Mike here that we normally, I believe that we might have said verbally, like, okay, as long as we get the mail component, handled, we should be fine. Again, it doesn't mean we have to follow procedure accurately. You could shake your head a lot, but we still have procedure, because if it gets appealed, it will extend much further down. So I don't know if, I think we have to take Carrie's advice here and unfortunately um, push this one more month down the road. I also do think that, um, it probably may make sense to involve just making sure the city is aware of it. I understand you have, particular, use, for the purpose of improvements related to the services you're providing. So, I mean, we want to make sure you can be able to do that.
Well, let me say this. The mayor knows about this project. Laura Richards knows about this project. The alderman for this ward, Rob Savage, knows about this project. And I really don't know how much more we can do, given that this is the second time in front of the Board of Port Wardens.
Okay, and you're right, because the mail element from the first time did not occur per protocol. So we're sorry you missed the protocol portion of this one. I do apologize from the city that didn't occur, but we have a procedure we have to follow, and applicants are equally responsible for understanding the application they filled out that has these steps related to it. So I definitely, I'm sorry this is where it's at, but I do think it might be best that the quickest way to make this happen is to postpone it till the next meeting.
I'd also like to speak to the harbor master's point. I cannot verify, but I certainly can when I'm in the office on Thursday. But what she referenced was a condition of the lease of getting written agreement, not notice to the mayor or mayor's staff or the alderman. So that is something to keep in mind if this is postponed. If a written agreement is necessary by the city, that should be achieved.
Terry, who's in charge of enforcing that written agreement? Is it planning and zoning? Is it the lawyer's office?
Well, I would hope that Crab would be the one that would actually reach out to the administration and get that written agreement.
So they're
the
responsible
applicant.
for it. Okay.
It's the city manager.
City manager. Okay.
I just got just a general question. I sort of see what's happening here to some extent. I don't know if this is the proper time, but have you actually talked to each other? I mean, we're going to end up having a problem here from both ends. Have you all talked to each other about what might work out equitably among the two parties here?
No, we haven't. No, we have never spoken with it. I'm sorry. Can I speak?
Have you talked to him?
We've not on this issue. We've talked to many other issues, but he has never approached us. It's his would be his prerogative to approach us with an idea. So the other big thing is this is being presented as maintenance, whereas we showed plenty of pictures showing that this is not maintenance. This is a new fill project on an area where there's never a beach, there's never filled. So if you go to the city and say our contract says you can maintain the property, we're going to dispute that that's maintenance. We have documentary evidence showing that this is not maintenance. So this is a new fill project.
Just out of curiosity, do you have evidence that your contractor got permission to remove that, you call it a pile of rubble, but it might have been a jetty? Was there anything in writing?
It was never a permitted structure. It was never
just
presented to the
Okay, that wasn't the question. The question was, did anyone from the construction company and or the...
I don't know.
We don't know. They removed it. They couldn't get their barge in close enough. They said it will puncture our barge and sink it.
Okay.
So they took it out.
And then MDE came because Mr. Bollinger suggested they make a site visit. So MDE sent three people to our house, and they reviewed the structure and the before and after, and they said you cannot put that back. Somebody put that in there as like a middle of the night kind of thing 50 years ago, and you cannot put it back. If you want to put it back, you have to apply for an environmental permit. You have to go to the port wardens, blah, 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 blah. And we said, okay, fine, whatever, thank you.
All right, let's
that's-
go ahead. We're going to take Carrie's advice here. I don't know if we have to take a vote for this purpose, Carrie, or if we just administratively. And again, I apologize, but it looks like the most efficient and effective way is to make sure we cross our I's and dot our T's, everyone here, with the whole process portion of it, and we'll rehear this at the next.
If
So
I
you
recall,
You have two
Sure.
options. You can do a motion to postpone the hearing to the next meeting, or you can close the public hearing and then make a motion to postpone a decision to the next hearing. So it depends on whether or not there's more evidence that you're waiting on.
or he can withdraw the application right now, can he not? And resubmit it.
If we don't have the proper notice, then we might have to reopen to the public to comment.
Right.
Yep.
So I would, Carrie, what was the first option you recommended?
I forgot. So I can't remember which one I said first. So I said you have two options. One is to postpone the public hearings, continue the public hearing, which is sort of what Jonathan was saying, and which I agree with because of the notice issue. And if there's additional evidence that comes in, like if you're waiting for some proof of written consent from the city manager that these improvements are okay to be made. Or the other option was to close the public hearing and postpone deliberations and a decision to the next meeting.
Okay, I would probably recommend, and Port Wardens, obviously I want to hear from you that we postpone this till the next meeting. But making sure, again, let's just, all of us, cross our I's and dot our T's, or vice versa.
I think
and make
what
sure
you need to
everything
say is
proceeds.
what this is. You said to make a motion, postpone this to the next meeting. What do you mean by this?
This application.
So do you want to continue the public hearing at the next meeting?
Yes.
Well, quick question, wasn't there a problem with the, was proper signage posted 10 days ahead of time?
Not
So
of
the
this
issue was
meeting,
at the last meeting, Harold.
but not
At
this
the
meeting.
last meeting, the signage was fine. The signage was for the last meeting. It was 10 days prior, and then presumably 10 days after. The issue at the last meeting was the notice was not mailed out. Now, the issue at this meeting was notice was mailed out, but the signage had not been updated with the correct date and then reposted. So two separate issues, both having to do with notice, but the different forms of notice.
So at this point, are both notices okay? Because it sounds like one.
No, it has to be.
It will have to
It
be.
wasn't.
It will have to be a
sequence
new
because
sign
of public
and
hearing.
new notice
Okay.
mailed.
Okay.
There is a new, presumably, if you guys vote on the motion to postpone or to continue the hearing, there will be new mailings that have to go out and new signage that needs to be posted.
What's the difference between that and just withdrawing the application, reapplying it again for next time?
We don't.
There are a lot of differences.
Yeah, this is the most effective and efficient for Crab.
Okay.
To do it.
Okay. Just
To leave it open, and then we'll go through the process. But again, let's just. I will dig into it and verify 10 days prior, and make sure sort of it goes as smooth as can be for our next meeting.
This would apply to the newspaper, right? Newspaper, mailings, and signage, right? Those three.
Correct. Correct.
Mm-hmm.
Well, I would defer to whatever is the requirement on the application, because if there's some small nuance, I'd like it, that's what every applicant has in front of them.
Yeah, Mr. McCobb, at this point, all three of those will be, those boxes will be checked: newspaper, mailings, and updated signage.
Okay. All right. Thank you both. I will meet again next month. So,
Need a motion.
thank you, Carrie. Awesome.
So we need a motion.
Yeah.
Yeah, so we need a motion. I can't make it, but a motion to keep the public testimony open, and then it'll continue until the next old business of next meeting.
I make a motion to keep the public hearing open until our next Port Warden meeting in April.
I'll second the motion.
All right, thank you. First, and we got a second. Thank you. All those in favor, please state aye or yes.
Aye.
Aye. All right, that's unanimous. Thank you. All right, let's move to new business. If we can bring in all parties, Josh, related to the Rogers Heights Road, which is port 2026-00002. And of course, this is under new business, and it's to install a 15 by 18 boat lift on existing poles, all work, a max of 50 feet channelward towards of mean high water. Can we, I guess, Mr. Glazer?
Yes.
Okay, will you be providing testimony? And is there anyone else from the neighborhood or from that will be providing testimony?
No,
Okay.
just myself.
Okay, great. All right. If I can go ahead and swear you in briefly, and then we'll turn it over to you. Again, I'm a huge fan of sharing images, if you have any, just to make it super clear, even though I think it's pretty cut and dry, this app. That would be great. If not, I can help share for you if you need be. All right. So if you'd raise your right hand, please. You do solemnly swear and affirm under the penalty of perjury that the testimony you are about to give to the Port Wardens is the whole truth and nothing but the truth.
I do.
All right, thank you very much. All right, the floor is, one last thing is your educational background or a brief description of your relevant, it might be relevant to the application. That would be great.
Yeah, so I work for Boat Lifts Unlimited, which we are the ones who are conducting this permit, and then we'll conduct the install of this lift pending approval.
Okay.
So that's my relation to this case. Okay,
fantastic. All right, the floor is yours. Go ahead.
Yeah, so this one should be very, very easy. We're proposing to install a 15-foot wide by 18-foot long boat lift on existing poles at the community marina at Weems Cove. It's extremely simple. We're not doing any real marine construction work with driving poles or anything. All the structure is existing. We're just going to swing in there and install the lift pending approval. The applicant that this is in relation to is a homeowner in the Weems Cove community on Rogers Heights Road. The signage was posted March 12th when I also same day I picked it up at the county office. Mr. Meekins with Planning and Zoning can confirm that. I emailed him the pictures of the postage. Mailings were complete. I submitted the list of neighbors within 500 feet, I believe, was the requirement. And that's basically it. I mean, it's extremely cut and dry. There's no real, like I said, there's no pier pile work. It's just a lift going on poles.
Okay. All right. I apologize. I got a little out of step. Thank you very much. And that was great. I just want to go back to Mr. Meekins to do the typical, is there a preliminary matter? We accept the record of the applicant packet and staff report, any public comments. And would Mr. Meekins like to present any information over and above the written staff report and confirm any public comments?
Thank you, Mr. Chair. No additions to the staff report. We received no public comments, and I concur with Mr. Glazer. Mailings went out for surrounding properties 500 feet. The signs were posted. He did send pictures, and the newspaper ad was published.
Okay. All right. Thank you very much. So we have no other public testimony in the equation. So no rebuttal. That's fine. I really don't have any questions. Go ahead, Mr. Glazer.
Yeah, the last thing I forgot to include, we've received MDE approval for this project, which I
Okay.
believe was attached on the application.
Okay.
Just so I wanted to include that as well. So really all we're waiting on is um, if we were to receive the Port Wardens approval and then taking that to City of Annapolis to obtain the building permit for it.
Right. Yeah. And no, all those auxiliary permits, the great thing for the harbor masters are we know the city will not actually give the element out until all of those are received in. But thank you for notifying of that.
Yeah.
This is pretty straightforward. Um, uh, uh, I really don't have any questions. It's always nice when the consultant, especially the person who installs the boat lifts, comes in and sort of gives us all the facts. One thing is a just unrelated somewhat, but Mike and Beth, anytime I see a provisional line, it always, again, I just want to reaffirm the concept of it will be great when we have a GIS image of everything. And the one good GIS that sort of half breed from that one other consultant that really is great because it's an overlay for Google Earth actually stops at Rail Boulevard. So it just throwing this out there, if we ever refer back to this application, we got to remember to get the rest of Weems Creek above 50, so it's easy to see. But I think you laid it out perfectly. I know those docks were permitted appropriately, so just fitting a lift inside of it is perfect. All right. Are there I don't really have any additional questions. Any of the port wardens have any particular questions?
Nope.
None. Okay. Great. After all questions are asked, I declare the public hearing for Port 2026-00002 Rogers Heights Road closed. This all meets all of our Title 15. There's no issue with navigation. There's no issue with the building material. There's no issue. I mean, we can get into the specific sort of titles. I know sometimes Carrie likes when we do it, but there's no issue with navigation 15, 16, 20. There's no effect on wildlife or pollution, but 15, 16, 30. So I think we're all fine statutorily without a question. But let's go ahead. Do you guys want to discuss any of the criteria in the statute? 15? Okay. All right. I'll entertain a motion to approve or deny the application.
Motion to approve.
All right, Mr. McCop, can I get a second? Mr.
Second.
Lerner, thank you very much. All right. All those in favor of approving the application Port 2026-00002 Rogers Heights Road, please state aye or yes. Aye. All right. Thank you. That was unanimous. The application is granted. Let's go ahead and move on to miscellany. Thank you very much, by the way. He already disappeared, but thanks for presenting. Okay, so the next item on the agenda is city council things. I'm glad Mr. Thorpe is here, or Alderman Thorpe is here, and as well as Beth, because again, this has to do with the moorings. The matter is 02-26. And I have the one that was the first reader bundle. I sort of feel like I had a newer one, but I couldn't tell if that's official that related to the mayor. Can you share, Mr. Thorpe? Do you have the latest and greatest flavor?
I sure can.
Okay.
Thank you very much, Mr. Chairman. This is it's become a little more of a difficult topic to work through. So there actually is not a later version yet. There's a draft that's going around. I've had numerous conversations with the mayor and Alderwoman O'Neill, who's very involved in this as it affects her ward, Weems Creek. So where we are right now, we're continuing to work through this issue. There is not an amendment or a new version ready to go to the Port Wardens. And we will definitely come back to you when it is. It's a matter of making sure that as we work through this with the harbor master and with Deputy City Manager Gould and the Office of Law, that we make sure that we get everything right as we go forward. And we are not ready to bring it to you yet.
Okay. There is one gentleman who did show up for public testimony. I probably need to ask Carrie if we really don't have anything to comment on. I'm not quite sure how involved. I definitely would like Beth to speak since she is with the city and, harbor master and part of this equation. You know, Mr. Thorpe, is it going in front of the next month's city council?
No, it will not go to the city council until the Board of Port Wardens reviews what will go to the city council.
Okay, but we don't really have the latest version to review.
So, and
Correct.
I also say that with the caveat of there is a 90-day. So I believe Environmental Matters is waiting to get the reports from both Port Wardens and the Maritime Advisory Board before they consider the legislation. But once 90 days hits after the legislation's been introduced, it sort of automatically gets discharged from the committee and goes back on the council's agenda. So you guys do have a couple of options here, as Alderman Thorpe indicated, that there's some sort of behind the scenes workings as it relates to amendments. So your options are to consider the ordinance as is with the understanding that there are amendments in the works and just maybe not necessarily knowing what those finalized amendments are, or postponing to the next meeting and with the hopes of amendments being, I guess, finalized, agreed upon. I don't want to sort of step on Alderman Thorpe's toes, but
Yeah.
those are options to consider.
So, Mr. Chairman,
Yeah, please.
Carrie is the 90-day requirement. Would it be legal and appropriate if we get to the 90 days that the city council take action to postpone discussion on it until the next meeting, i.e. until the Port Wardens actually do deliberate on it? Because there's nobody that wants this to go forward without the input of the Port Wardens. We want to make sure we stay within the guidelines that the city council has. So is there a way we can do that?
Yeah, so sure. So if it hits that 90-day mark, which I'm not sure we're quite there yet, I think we're closer to maybe the 60-day mark. Just don't quote me on that because math has never been my strong suit. But if it gets automatically discharged back to the council, then the council has the ability to sort of kick it back to the standing committees. And I truthfully do not know what the status before the Maritime Advisory Board, but let's just say for argument's sake that, like the Port Wardens, they haven't issued a recommendation or a report or anything like that. The council can say, we want it to go back to these entities and we are going to postpone it until these entities have had the ability to weigh in on it. And then once they, give their recommendation, then it'll go back on the city council agenda. Or the city council can say, we're going to postpone it to the next city council agenda with the hopes that the Port Wardens would meet in between and can sort of continue to postpone it each meeting afterwards until their desire has been met, which is Port Wardens and or Maritime Advisory Board and or, Environmental Matters Committee has met on the legislation and given their recommendation.
All right. Can I ask briefly, is it fruitful or useless for us to even be discussing this without having a real version of what is to be discussed,
or at least a background? Can you give us a taste of something? Can you give us a little something so we can?
Well, so just so that you guys are clear, you guys were sent the ordinance,
right? And I've read it, but it's not really it looks like it's being shelved to be reworked and then to be represented.
So let me suggest this. Maybe hear what the harbor master has to say, and then you
Sure.
guys can sort of make the determination that whether or not you want to hear more, whether or not
Sure.
you want to postpone, but so that you can get the background or whatever context that you're looking for now as to what the ordinance is, and then
I
the
think
next step.
right. That's a great idea. That's a great idea.
That makes a lot of sense. Just I would encourage you. You could be here all night doing it. So
Right.
and I think speaking definitely for Alderwoman O'Neill and for the mayor, the input provided by the Board of Port Wardens is very valuable as we move forward. So
Okay, then that I like to hear that. Although we don't want to go. Let me get Beth out, and then I think we can have a brief discussion. I do hope the Port Wardens have read. We did receive it. It was also in the City Council, so we sort of have a sense of what's going. They're trying to define it well, but let me turn it over to Beth, the harbor master.
Yeah, thank you so much. So we've sent a couple of emails to legislative analyst Cynthia Reuter to please produce the most recent amendment and legislation. And we thought it's done. We thought it was done. And so it's really disappointing to not move forward with this board at this time because we think it's succinct. We think it's good. I'm not sure what happened there. I don't know what version you have of this. I thought this board, I think that Rob, you were copied in an email earlier today saying, can you please produce this? We thought it was all done. I thought it was approved by all parties. And so we'd really like to move forward, and we would hate to wait another entire month.
Well, it's in City Council's hands. I mean, as far as no matter what, there's going to be an extension of it being finalized. I have the first reader, and then I got an email, I think just today or yesterday, that was like the mayor's version. But
is the city council never going to move forward until you opine or give
well,
some?
I'd like to opine now if possible, but but I also want to make sure all the port wardens have an opportunity as well. From a 30,000, if I may, tell me to hush up, Carrie, anytime. But from a 30,000-foot view, I think moorings in proper cities that boating are so central to really do a great job of allowing official moorings. One's maintained professionally, one's requiring inspection, one's requiring, specific specifications as to how they hold. I always say it's like a car not tied down right in a roll-on, roll-off car carrier. If one is not tied down right, every other boat gets damaged, right? In the case of one of our creeks, it could be a fixed dock. It could be a boat up on a boat lift. I've seen boats break free on Weems Creek and hit the bridge right at Ridgely. So I think it's an important matter. It also helps control the people who are sort of willing to just anchor anywhere that they feel like they can. So it takes a situation where you get to define certain areas of a creek, maybe entire creeks, as being managed versus ones that need to be enforced because people are just dropping anchor anywhere they choose. I think there has to be reasonableness with those that do have waterfront and may have been lucky that they've just had to cast away a few assorted boat show boats that drop anchor right in front of them. But it does, by putting a more permanent mooring, it does, again, bring the safety element and actually allows it to officially follow whatever rule we set. I do think in most cases, like I have this one document in front of me, and I would share it, that refers to what we're doing in parts of Spa Creek. And actually, the city does a good job of making sure the swing circle, which is what I would say when you have the mooring itself, and then you have a pennant, and then you have the length of the authorized vessel. As it were to spin, depending on the wind direction, that swing circle is what really matters as describing its distance. And I mean, there's up at the top of Spa, there's 110 feet, 107 feet, there's 85 feet, there's 75 feet between every single one of the moorings, at least it might be proposed 18, 19, 20, 21, and 22. So they already do a good job of describing the swing circle based on the length of the vessel that's permitted there, and then making sure it's not too close to shore. There may be some grandfather areas and there may be a way to have it written where there are areas that are grandfathered or waiting until the tackle need to be redealt with. But I do think that having a good definition. So again, the purpose is safety and it benefits everyone, including the property owner, as long as it's 75 feet outside of the swing circle. But it also, sort of protects the space. So that's my humble opinion. If you, Mr. Taylor, we'll get to you in a second. The Port Wardens are going to discuss, and then we can. I know you came for public comment, so we want to include you. But that's me. Let's ask some of the other Port Wardens how they feel about it.
But could I just, for
Yeah.
1 minute, could I just say, like, it's really important to sort of make things definitively different from the legislation, from what people are looking at, which is like a project. So there is a project, we all know about it. It's going to come before the Port Wardens in the future. So I think it's important to look at this legislation individually and separate
Okay.
from that. That's all.
Okay. Port Wardens?
Can I go next? One of the questions I had from the beginning was, had the city legislatures looked at what other cities and towns, municipalities, port authorities have done in terms of legislation in this matter? And I don't know if we have a good answer from Frank or Beth, if either of you have looked at other places to compare.
I have not received that information.
Okay.
What I can say is we've had a productive mooring field, both annual and transient, for more than 20 years, that have had no accidents. So I certainly could look at other jurisdictions. However, we don't see any problem with our existing mooring fields. They're very productive, they're very safe, and everything is perfect.
Okay,
So we haven't
that's interesting. But this is more in terms of how we write the legislation rather than like the outcome of the mooring fields. So a couple of things I'm thinking about. One, in terms of Robert, you'd mentioned like property owners and the ability to obtain a mooring field and whether those are private or public or permitted. It seems like that's an important distinction. Like it should be the case that every citizen can get a mooring if they want to. And the way the code is written is that there are private mooring fields that are permitted. And I was curious, like, do we have a permit process in place now for people to go and get a mooring or put one in according to the city's?
No.
We're trying to change from private. There's only very limited private. There's not enough water in the constrained areas of our creeks to allow every person to have one that they choose to have. That's why most towns go to city managed ones. Now, there are two different types of moorings. Correct me if I'm wrong, Beth or Tyler. We've got transient ones and we've got year-round ones. But the vast majority are all city maintained and are are there. There is a little bit of a mix problem, in my opinion, on Weems because the county, there is an MOU that's being discussed in some way, shape, or form, but the county side had some private ones that were put in because they have a different set of rules for the county. And of course, Weems Creek Center is split between county and city, but every other creek in Annapolis, except maybe College Creek. I don't believe we have any city ones on there. We are actually city, and they're either transient or they are year round.
So let's
And
say
the
like,
current rewrite of the legislation gets rid of private altogether, correct?
So there never were any private moorings. So that's a
There are a few
really,
that exist though, right? Somewhere.
there are some illegal moorings. I wouldn't call them private moorings.
Okay. There's some
So
moorings, some places that people have purchased from other people that do exist, right?
there,
They're not
there are
regulated by the
three.
city, or the city has no,
Yeah,
doesn't
so
know what
there are,
condition.
yeah, so there are three moorings in Weems Creek that were never properly permitted, and city code required them to be permitted. And because we never could ever ascertain the GPS coordinates for the city county line, we communicated with them. We never could sort of drop the hammer on them and say, like, hey, you can't have this, it's not permitted. And so those have persisted over the years. However, the only private moorings, and city code is not, Title 15 is not great on this. So in many times they call an annual mooring a private mooring. An annual mooring is not a private mooring. It is a mooring that is owned by the city that is leased to a particular person. So, so for those three people in Weems Creek, those are not private moorings; those are illegal moorings. But the only situation where you could have a private mooring would be if you had a big enough developable waterway. So let's just say, like, you had a really, like, let's just say, like, a hurricane took out your pier, or for whatever reason, the area between your shoreline and the harbor line was big enough that you had 75 feet around your mooring ball, which I don't even know if that exists. You could have what we're now going to call a riparian mooring ball. It's not a private, it is your private mooring ball, but we want to be very clear about what that looks like, and that's a riparian mooring ball. So we want to try to this legislation is designed to sort of clear up all the misconceptions about all of this stuff. And so it's really important to understand that the city is very fortunate in that DNR has given us the right to legislate or sort of like decide where our moorings go. And so if you look back in the history, I won't go too far into this. If you look back into the history, back into the 1970s, we're very congested because we have a lot of boats, right? So like sometime in the late 1970s, someone said, you know what, there's way too many anchored boats and this is not good and this is like unsafe and people are dragging anchor. So at some point, the city applied to the Department of Natural Resources and they said, you know what, you can decide where your moorings go. And you get this special dispensation, you get the special permission, and you can do it. And so now it's up to the city to decide where we put our mooring balls. And because we have that special permission, we also have this special responsibility. So if I live in any other creek in the state of Maryland, I can drop a mooring ball wherever I like. But in the state of in the city now, I have to go through this whole process with MDE and Army Corps of Engineering and the Board of Port Wardens. So everyone's making sure we do it perfectly and everyone's making sure we do it right. And so, you know, because we have these three folks that have sort of flown under the radar, not really on their own fault, but because we didn't really have a proper GPS reading, we're in this place where we have to get those in back into compliance. Does that make sense?
Yeah.
And my other question is around the 75-foot distance. Do you think that is the most efficient way for the city to manage a mooring field? where you might have a 15-foot Boston whaler on a mooring that maybe doesn't need a 75-foot swing. Could the city manage it more efficiently by doing sort of designing an efficient mooring field based on the length of the boats and not giving that?
Jonathan, they
permission
already
to
do that. The swing, they
do?
already tailor the swing. The 75 foot is the distance to a shore structure, either a
Okay.
dock or the riparian, right? It's not really the riparian, it's where 75 feet from a fixed structure is where, and the question that we
Gotcha.
have
Okay.
is the fact that it might not include the swing circle, which does calculate the guesstimated length of the vessel, plus a little bit for the pennant, plus a little bit of the movement of the chain attached to the helicoil, depending on tide. So you have to sort of calculate a little bit of that. But the 75 foot is actually, the distance from a shore structure. Okay.
Mm-hmm.
Does
Yeah,
this,
so
go
we
ahead.
also have like all of our Ashley Leonard's done a fantastic job of making sure that all of our contracts and all of our I don't know if Carrie could speak this better than I could, but whatever it is that we decide is a good idea in terms of policy, she's made sure it's all approved by council and all of that stuff. And I couldn't succinctly say what it says in city code, but working with what our decisions are with the mooring fields, then we also decide what makes sense for a maximum size boat. For example, for an annual mooring boat, it can't be more than 42 feet. For a transient boat, it can't be more than 55 feet. And we've looked at all of those measurements, and we know based on 15, 20, more than 20 years of data, we know that works. There's no accidents. The boats work well in that mooring field. Everyone can get to and from their docks. And so we know that works. And we also have gotten all of that stuff sort of formally accepted by council as we've gone through these contracts. I would like to think that is working well. I know that it's working well.
Question. Does any of this legislation affect somebody from dropping their own anchor? And is there any legislation about where someone can drop their own anchor off their boat in city waters?
So that's a very good question. And I don't know if Tyler has that list of places. So if we put in more moorings, there will certainly be fewer places that people can drop anchor. However, there are still 5 places that you can drop anchor in Spa Creek, which will be the most affected place. And do you have that list, Tyler?
And how does somebody know where?
Let's see.
It's
Hold
around
on.
President's Point. You'll be able to anchor in front of
So
oh,
Wells
let me pull
Cove,
up
you can
what
anchor
was
by
that.
Wells Cove, President's Point, off Truxton Mooring Field, off of Revel between the Green Can and the mooring number 30. So yes, there are still plenty of places that you can anchor.
How does somebody coming into the city know? Is there diagrams?
Harold, in all the other cities, like you can go online to the harbor master for them, and like Nantucket, it'll show you the area that's the grid mooring field, and then it shows an area inside of the harbor where it's a considered anchorage area, and they usually define it, and it's usually published, on the website of the particular harbor master.
We do have that.
Yeah, we do have it. We can certainly beef that up if this legislation passes, to make sure everything makes sense for everyone.
John, any more harbor master? I do want to get to Mr. Taylor briefly.
No.
Okay, Mr. Taylor?
All right, Mr. Chairman.
Yes.
Mr. Chairman, I have some comments, but I'd also, Deputy City Manager Gould, who's been very involved in this, has had her hand up a while.
Oh, okay. All right. I'm sorry. I didn't see that. Yeah, I see that now. I apologize, Scott. Can go ahead.
Thank you. So earlier you asked the question, what, to summarize this legislation, and it is really quite simple. What this legislation does is it started with a technical correction. Originally, the legislation said that we were measuring the 75 feet from the vessel that was tied to the mooring. What this legislation does is correct that, and the measurement is made from the mooring, not the vessel. So that's really the crux of this legislation, is just that technical correction, that the measurement is made from the mooring to any other structure, pier, whatever. The other issue, and the one that spiked some people's attention, was the misuse of the word private mooring in the legislation, which has now been corrected in the amendment. The private moorings are actually annual moorings. So there's only transient moorings, and that's defined, annual moorings, and that's defined, and then this new definition of riparian moorings, which the harbor master has explained is put within someone's developable waterway if in the very rare instance they actually had the room to do that. Some people came to the hearing on this legislation thinking that they indeed had private moorings when they had illegal moorings. So that's it in a nutshell. It's a technical correction and then cleaning up of the language about private versus annual.
Oh,
Okay, so let me, Mr. Chairman.
yeah.
So let me clarify and go on the record and say, speaking for Alderwoman O'Neill and myself, and I believe the mayor, there is nobody who has an illegal mooring in city waters. And that's the crux of this issue, is we've got to work through, as elected officials, how to deal with people who have believed that they were operating on a legal mooring, and what do we do moving forward. That's why we need some more time.
Okay. I'd like to say, just so because I think some of the math, the 75-foot mooring to a shoreline is not realistic. Okay. You know what a mooring pennant is, right? That's the last final item that connects to the actual mooring ball between the vessel. For a 23,000-pound boat, which is about a 42-footer, depends on how much power is inside of it. It's 20 feet is the recommended. So that means you've got 42 feet plus 20 feet, which means this vessel could swing 60, effectively 62 feet, right? Up against, which really, tightens it up for someone getting their boat out of their respective location. It also tightens up the area if someone's running a generator for that thing. I just feel like we've got to be talking about the swing circle of a vessel we're on there. That is, am I wrong that 62 is a little tight when you only have 75 feet to a structure?
Well, as Beth was saying, the harbor master is determining what the best vessel is for a particular mooring. So probably the harbor master would have the jurisdiction not to put a 42 foot vessel there. And put that Boston whaler instead, right?
Yeah.
Yeah.
And that may make sense. It also may make sense on the structure. Like if you take a natural shoreline, it's a little different than having someone who has a dock where their vessel departs directly into the harbor line, So I agree, and I trust the harbor masters to make that right decision. I just,
I just wonder if the code could be written in a way where we're not determining a set number of feet, and we put it in, maybe the harbor master wouldn't like this, but we let the harbor master decide what the correct vessel is in the correct position and the correct distance from.
So that's already in code. The code already specifies that the harbor master will determine, and then we do it in a formal way. Like we have a contract for our annual moorings that's approved by council. It's formally approved. So it's nothing, it's all above board. So
Yeah.
what, say again?
Yeah, yeah. I'm just wondering why we're adding this legislation if that's already there, if we already have control of the situation with the
We,
with the
yeah,
legislation that you and the power you have.
so the reason we have this legislation is we're correcting it. So right now it's saying that a boat can't be within 75 feet of a mooring or shoreline or a pier. And that's not happening. So right now we'd have to deinstall most of our moorings because that wasn't
Yeah.
written properly. So what it needs to say is our moorings, because we already have this other legislation, or I don't even know, policy that says the harbor master can determine, and we did it through a formal process that was approved by council, the maximum size of the boat. So even though the moorings are 75 or 80 or 100 feet, we know that these particular moorings can only hold a 42-foot boat or a 35-foot boat or a 55-foot boat. We already know that we've done that. We've done it through a formal process to make sure everything works well. And we've done it for more than 10 years and everything works perfectly. There's been no accidents. So
Yeah,
we're correcting the legislation because the legislation doesn't work when we're saying, because when we say a boat can't be 75 feet from a mooring, then every single mooring, whenever we put a boat on it, is in violation. Does that make sense?
The
Yeah,
whole
so what
front
I'm
board would be in
suggesting is that
violation.
you just when you correct the legislation, you get rid of the 75-foot requirement. And then because you already have legislation to place vessels where they need to go, we don't need additional legislation. That's sort of my point.
I think your point is great. I just don't think other people would trust me enough. If that makes sense.
Yeah, I mean, I think that it could be written in a way to I don't know. I think we should simplify things, if
I
I don't
agree.
know.
I just want the public to trust. I want the public to trust the harbor master's office to do a great job, and I know that we do. But I just don't know. Like we thought that this legislation worked to accomplish that. That's what we. That's what we feel very confident about.
Okay.
As an aside, Beth, there are how many permanent moorings are yearly are there right now?
46.
Okay, if they are all taken, can the person who has it continually to renew it, or is there a way to have somebody new come in?
So
I mean,
they
once
can.
somebody has it,
They
are
have
they
the
locked
first.
in?
They have the first right of refusal, if that makes sense.
Okay, yeah.
So
And
if
they have
they
to follow
don't,
a set of rules of use, right? Which
yeah,
the harbor master does a great job of enforcing, literally
yeah.
counting, making sure the right vessel's there and stuff. So.
If they don't renew by February 15th, then someone else gets to have at it.
Are they all being used right now?
Yes, all but one.
I do want to give Mr. Taylor a chance. He did show up. We did talk about public comment. And again, it might actually give Mr. Thorpe and everyone else, Jackie, and like as they finish this crafting of the element. So Mr. Taylor, please. You're muted.
No, can you
Now
hear
I can
me?
hear you. Okay.
Yeah. Good evening, Mr. Chairman, members of the Port Wardens. My name is John Taylor, and I'm here with my wife, Cindy Domacy. We live on the very inland end of Spar Creek, and to try and cut to the heart of the issue, the 75-foot requirement that has been discussed already over the last 20 or 30 minutes. To me, there are two elements of that. One is the spacing between mooring balls. And personally, as Ms. Bellis has described, I don't see any problem with having a 75-foot mooring ball to mooring ball requirement. Seems eminently sensible. The one that does not seem sensible is 75 feet between mooring balls and fixed structures, such as all the piers all the way along Spa Creek. There will shortly be, well, there are already 75-foot moorings in the city. So if you have sorry, did I say 55-foot boat mooring balls? So if you have a 55-foot boat and the mooring ball is 75 feet from the dock, that boat will eventually hit the dock. It's just that simple. Some combination of wind and tide, it'll hit the dock. If it doesn't hit the dock, the gap between the swing of the boat and the dock will be so small that it's not navigable for people who live on the creek and for people who use the creek. So I think I sent you actually suggested language that would make it clear that it's 75 foot from the swing of the boat to any fixed object. And then that would take care of my objection. Thank you.
So I might speak to that.
Sure.
And I hope Tyler will weigh in.
So so when we talk about a 55-foot mooring ball, that when that is laid out by the engineers and design firm, that is a 125-foot radius. So it takes the 55-foot boat plus your scope, your pennant, and we make that 125-foot circle. With that circle, we then have 75 feet away from every structure. So from Mr. Taylor's standpoint, that what he said is not accurate what we're doing. We're taking that, we have a 55-foot mooring, we take 125 feet of circle around that mooring, and that's where that boat's going to fall. Then we have the 75-foot rule after that to a structure. Does that make sense?
If I may reply to that, yes, I understand that, but there's a process here for changing the city code, and in changing the city code, it changes it from the old wording, which says that a vessel may not be within 75 feet of a fixed structure, to the mooring ball may not be within 75 feet of the fixed structure. So if we're making a change, why would we make a change that on the face of it might allow a moored boat to hit a dock? Yeah, I accept that or I hope and accept your word that you would design which boats go on which moorings to achieve that. But what about a future city? A different harbor master or a different harbor master staff. We're changing the city code here. This is the code that dictates what residents and what the harbor master can and cannot do. And I think we should not have a situation where, in theory, a moored boat could hit a dock or be so close to the dock that it is no longer navigable.
Yeah, I think it's
Safely
really
navigable.
Thank you for your thoughts. I think it's really important to understand that these moorings have been in place in that exact situation for more than 25, 30 years. Tyler can speak to that. With 0 accidents. So they're very functional. They're very revenue, like they make a lot of money. So there are no problems with our mooring field. So to change that, this is a correction. This legislation is merely a correction. So right now, would we want to deinstall more than 50% of the city's moorings when it's a very functional, very productive mooring field and everyone's happy with it? So if we look back on the history of mooring fields, back into the 1970s and beyond, what we know is um, that the city of Annapolis it's a very popular place to go. There's tons of amenities, right? So there came a time when boats were anchored, and there were so many boats that the city of Annapolis petitioned the state of Maryland and said, you know what? We need a special mooring field because boats are dragging anchor. This is a mess. And so we could go and delve down into that history. But I know. Say again.
I'm trying to understand what field. I mean, to me, Spa Creek, the upper 40, they're all 78 feet apart, and they're well apart from the shoreline. I'm not seeing where field are an issue. I haven't checked the St. Mary's field, but where are we talking about that you aren't already 75 feet?
So we're talking about, like, say you have the front 40 is totally filled. You don't have 75 feet between your bow and the guy in front of you stern. This is what the
Right.
75-foot rule is correcting.
Right, but as we know, they swing the same way. I mean, I'm more concerned about the physical structure part of like the riparian right holder, over on the shoreline. Do we have any that are within 75 feet of that?
They're on the line. They're close. I think Wells Cove is very close.
Okay, all right.
I mean, even if we have riparian moorings, it seems like they need to follow the same permitting process that every other mooring would go through, and that the harbor master would set the location so as not to do anything else.
We're not the riparian. I'm not talking about. I'm just saying like a home or a private structure out there. I'm not talking about a riparian mooring like she had described. If someone had owned enough waterfront to have their own mooring, we're not talking about that. At least that's not what I meant. If that came out that way.
No, I mean, I guess I would love to figure out how we can allay Mr. Taylor's concerns.
Beth, what is the situation now if there is a structure that's hit by a boat or vice, is there enforcement action? If somebody's boat actually runs into somebody's pier, who's responsible? What happens now?
I'm not sure I understand your exact scenario. Can you help me understand that?
Let's assume the boat swings and it does hit the pier. What happens then?
That has never happened. That can't happen.
It won't happen on a city mooring.
The only way that can happen is an anchored boat that drags anchor.
Well, that's John's question in reality. He wants to know if his boat swings and hits his pier. Or
that can't happen.
Not on a mooring. It can only happen on anchor.
Another thing, just as a boater, I mean, there is a nice, if you think about I'm just spitballing here, but think about the setback between your front property and the actual sidewalk, and then the public access grass area, and then the street, right? There's a natural area that we all agree that we may own the property and have to maintain it, including the sidewalks. However, we keep it open for people to walk, and we keep it open for people to park right out in front of that. That's the one area that I keep going about this swing circle and 75 feet. Is that 75 feet of width is a wonderful, safe navigating area that is not going to get swept with the transom of a boat that might be protruding into that 75 feet. If you're literally thinking yourself on a whale or going around Spa Creek, right? That's the best views. That's the best, and yes, you might have a situation where some days the wind is blowing from the east or the west or pushing boats in a different way, but leaving that access area, right? That thoroughfare of the distance from a shore object and where we do decide to do city moorings, which I think is a great cause that we should be doing in all of our creeks. It does leave that open. And again, it is going to be measured from the transom of the vessel. Now, again, I do trust Beth and Tyler to pick the right a permissible length in that respective location. But protecting the 75, if we're changing a code, is not a bad concept. It's like protecting that sidewalk and grass and curb that's for park. You know what I'm saying? Any thoughts to that, or am I?
I
Totally agree.
what I would say if I was a waterfront, if I was a riparian owner, I get that that makes you very nervous. I understand that. What I know after 30 years of maritime law enforcement is that the anchored boater is far more dangerous than
Oh,
the moored boater.
we know that. We agree. And again, that's where we simply say no anchorage in only moorings. That's what most cities do in tight areas like this. I think that makes a lot of sense. It reduces your enforcement need. It reduces, the types of boater that like to raft up and anchor and make a sort of a party wherever they choose. I'm not to say there's anything wrong with that. I just, you know, I think that that's a non-issue about the safety if we actually also, and Alderman Thorpe might want to talk about that in this thing, is if we simply say our congested areas should be city moorings and a combo of transient mixed with year round, depending on the particular area, that we're talking about. And like I said, I believe, most towns in New England that have had moorings for years have situations set up like this, that have defined anchorage areas and defined mooring areas. And the closer you get to the shoreline in those areas are all defined mooring areas. Take Newport, for example. Go ahead, Ms. Alderman.
Yeah, so if I could just ask a question, and perhaps for Mr. Taylor or Ms. Bellis, the other way to look at this is from the structure to the buoy, the mooring buoy. So if it's 75 feet and there's a 30-foot boat on the mooring with a 15-foot road, that's 45 feet. That leaves you 30 feet between the stern and the pier. And if the person who owns the pier has a 40-foot boat coming out, do we have another problem? Is that your point, Mr. Taylor?
That's certainly one of them. I mean, there's two. One is navigation along the creek in the most adverse conditions, where the swing of the moored boat has come close, its closest approach to the dock. And remember that the at certain times of the year, Spa Creek is quite busy, and we need to have boats passing each other. Also, please remember there are quite a few large catamarans on Spa Creek, and they are 25 or between 25 and 30 feet wide. So we've been talking about, this navigable gap being less than 75 feet. Well, we might have the situation, if we're not very careful, where if a catamaran is coming up the creek, no other vessels can transit the creek. So I think that 75-foot buffer that the chairman so eloquently described, is an excellent, is what I'm aiming for. That's exactly what I'm proposing.
I mean, we have this language in the port wardens it says like not to impede navigation or something like that. We could write that instead of putting in the 75 foot and trying to debate the semantics of whether 75 feet is sufficient or not. If you write that it shall not impede navigation or not cause damage to other structures, you effectively get the same result, giving the harbor master plenty of leeway and trust that they won't impede navigation and damage structures without being set to 75 feet. Ultimately, it might be the same thing, but I don't know. Just a thought.
I mean, I'm just of the opinion that if we're going to change the city code, we should put in very precisely what the city, the residents, and the port wardens think is a navigable corridor between the swing of a vessel and a fixed structure such as a dock in all reasonable weather conditions. And I would add that too.
I think Tyler had his hand up.
Sure, I didn't. Oh,
Can
there.
I share
Tyler, go
something
ahead.
real quick just to see, to kind of explain everything? This is an example. Everyone see my screen?
Here we go. Yeah.
So are we talking about exactly in position between each mooring balls, or are we talking about this? This is their 75-foot buffer. This is the max size boat a mooring would swing.
Right. This is great. This is why I trust you guys and I know this hasn't come forward to us entirely, but this is that example I was describing that you guys seem to do it right regardless. There's more than 75 feet between any sort of fixed structure.
All that kind of stuff.
Yeah.
So we're not going to throw moorings anywhere we want. We're going to go through and make sure everything's safe, navigable, all that kind of stuff.
Can I add though? This is version 2 of that plan. Version 1 of that plan, these 5 mooring balls that are shown on the screen right now were all within 75 feet of the piers. And it was I presume, upon my objection to the company who's doing this planning for the city, that version 2 of the plan had pulled them back so they were at least 75 feet.
Well, I don't think it was from your objection. I don't think that's so, but
No.
I certainly did object, and not too long after it was changed. So I don't know the internal process.
But doesn't this diagram show 75 feet from the harbor line? No, from the
Shoreline
it's
on the lower
shoreline,
portion and
not
dock.
the harbor line. Yeah, on the top of it, it shows 75 feet from the harbor line. On the bottom of it, it doesn't.
I
There's
think it's
no
meant to
fixed
go to the
structure.
structures.
There's
I don't
only
think it's
land on that side.
Mhm.
Living shoreline, effectively.
Gotcha.
Okay.
And I agree that this version of the plan shows 75 feet. And so I think the city is de facto agreeing that 75 feet, a 75-foot navigation buffer, or whatever you wish to call it, is appropriate. And if so, if that's the case, it should be in the code.
well, we would have to deinstall 16 mooring buoys that function very well. So we wouldn't like to deinstall 16 mooring buoys.
Is there a way, Alderman Thorpe, that there's a grandfather scenario where like it's written in such a way that we keep certain fields as is until the point at which they get or we dedicate certain fields to different sizes. Is there? I understand it's way easier to have a simplistic single sentence or double sentence sort of code, but it may it may, I mean, there is a big difference between 13-foot, 15-foot whaler sitting on a mooring ball and then admittedly, like, we want to maximize not maximize the revenue, but maximize the usability for God knows we have a wait list for Spa and a couple of the other creeks. So there may be, maybe we're trying to make it too easy, and maybe we have the mix. Maybe we look at those smaller fields that have the ability to be slightly tighter because their vessel size is a 20 or a 24 or something like that, or 30.
Yeah, so let me state one thing. It is my personal interest that maritime is more important than revenue on
Yeah,
this.
I agree.
So as we move forward, and The second thing I would say is I think you've just gotten into the conversation about what gets grandfathered, what gets a grace period. That's really what we're working through.
Okay.
Why this isn't ready is we've got to work through how do we ensure that we listen to and take into account the mariners' concerns, who, like Mr. Taylor, like people who have these mooring buoys on Weems Creek, and how do we create the best rules for the future for maritime that clearly the harbor master is looking to do, and ensure that we do the right thing by the mariners. And so that you've nailed the crux of the issue and why I am biting my tongue throughout this. And I think, to your earlier point, this has been very helpful, I think, for us to listen to, because it really does put the crux of the issue. This is difficult, and this is what the harbor master is trying to work through. And so, yes, I would say all those ideas are exactly what the mayor and Alderwoman O'Neill and I are talking about.
Okay, great. All right, I think is there anything else from Port Wardens about? I think we beat this one pretty. There's more to discuss, but I think and I do really appreciate Mr. Taylor coming in, and of course Tyler and Beth, sort of being part of this, and we look forward to seeing what you guys come up with.
I'd like to make the motion to just postpone.
Well, I don't think this is a vote. I mean,
is there anything we need to?
Miscellany. I think this is just discussion, right? Karen?
You would want to vote on any recommendations that you would make or postpone or what have you. But the goal is that you guys produce recommendations of some sort for the council to consider when considering O2 on final reader or second reader.
So it's like a motion then just to continue discussions next meeting. How would you express it?
Again, this is a discussion and Carrie, I understand what you're requesting, but it appears there really isn't something to comment on quite yet. We've had great discussions of the different components, and hopefully Mr. Thorpe will be able to take that to the other constituents and then say, look, this was discussed, this idea, this was, and maybe there's the mix, but I don't know if we're ready to present.
But just to be clear, Carrie, the city council has tasked the Port Wardens to opine or give a recommendation about this. And then if they don't, then what is the repercussion on that? Just to be clear.
I don't know that there is a repercussion. I think that, I can't speak on behalf of the city council, but I think that the preference is if there isn't action to be taken or a recommendation to be made, that is something that is articulated by the Port Wardens as opposed to not saying anything at all. So I think they want to hear something from the Port Wardens. By the time
it seems to me that the council doesn't want to hear from us yet. Correct? Is that correct?
No, I think so. So what Alderman Thorpe was talking about is conversations about an amendment to the legislation. And so that's not to say that it's up to you whether or not you want to make a recommendation or not make a recommendation based on the legislation as written, or whether you want more information as it relates to the amendment that's been discussed or the amendments that have been discussed.
I possibly heard it wrong, but I sort of thought that it's been sort of shelved at this point while it's being discussed. I mean, that's how this started off. So
yeah, let me
are we supposed to look at the version we received, which was first reader, and then you want us to make a recommendation based on solely the first reader? Or am I incorrect in this started by saying that was already outdated?
Yeah, so I asked for Cynthia Reuter to give you everything. If you didn't get that, I apologize.
So, yeah, let me try to dovetail with what Carrie said. And um, the city council and the mayor would always be welcome to hearing anything that the Maritime Advisory Board and the port wardens have to say. The point here being is there is not legislation that the mayor and two city council members involved are ready to put forward to you or to the city council. So if you'd like to have anything to say, and I know that Alderwoman O'Neill wanted to be here. She had a schedule conflict, but she'll watch this later, so she'll hear all of this discussion, and we'll back brief the mayor. But so I would never want to tell the port wardens that you shouldn't say anything or shouldn't opine. But what but there will be another bite at this apple when we present to you the legislation that will be going forward to the city council to amend the current legislation.
Okay.
To be clear, and I think this is what Beth was just referencing, there is an amendment 1 that has been uploaded into Legistar. Whether or not you, the port wardens, have read it or have seen it, I believe that is what Beth is referring to as the amendment. And I think that same amendment is what Alderman Thorpe is discussing, that there might be some massaging of that needs to be done. And so that may get reworked in some form or fashion. And Alderman Thorpe, please correct me if I'm misunderstanding that.
Yeah, no, I think you've got it right. I think there's a technicality here. I'm not sure which alderman or the mayor personally took a step to make it in Legistar, that's the software that we use. Um, but I can speak for the mayor and Alderwoman O'Neill and I that it is not the version that is going to go forward to the city council.
Okay,
It
just
sounds
so
like
you
you're going
guys
to
know
do
what
more
we've
than massage
received.
it.
Right, we've received first reader 02326, 0226 Amendment 1, but Littman only.
Yeah, that's the one that's been introduced and that Beth is referring to, and that Alderman Thorpe is also referring to. That
Okay, and that
was that
arrived
there's-
today at 12:30 for the record.
Robert, what do
yeah.
you think about if we just made some general recommendations
Yeah,
that are
I
not
think that's a
specific to a
great
piece of legislation?
idea, so that it's sort of on the record. Although I'd gladly, like, if we want to have something written to summarize, we can do that as well. But yeah, I agree with that. And again, I don't know if we have to make a motion to do this. Carrie, you can correct me, but do we want to summarize? Each of us summarize one point. Mine is that thoroughfare.
Well, hold on,
Yeah.
before you get into that, I think you also want to discuss like the format and how you present this to the council, meaning like, are you going to have a sort of something in writing submitted to the council, or are you expecting Mike to take notes and submit something in writing to the council, just to make what your expectations are and getting that message to the council clear, so that those who need to act are aware of how they need to act moving forward to get the message to the council.
Okay.
Why are we trying to get a message to the council before we've seen what the council wants us to see?
So that we can influence the legislation before they write it.
Right.
We can
so
do
they
that
don't keep
after
going
they
back
write
to
it.
the
We could do it before.
right. And
But
we're
we don't have any idea what.
Okay. So I'm clear. The council wants you to see O2 on first reader and the amendment to O2. That is what is for your consideration right now. There may be some additional amendments. And so if you want to wait to see those amendments, then you can act based on that desire. But right now, the only things that are before you and the only things that you need to really be thinking about are what is stated in O2 and that proposed amendment. It's not a matter of the council hasn't had anything that doesn't have anything for you guys to review, because that is exactly what O2 is. The amendments are not going to be introduced by the entire council. It's going to be members of the city council introducing amendments, much like Amendment 1 is introduced by Mayor Littman. He may withdraw it at some point. There may be additional amendments, but as with all the respect in the world to Alderman Thorpe, he is well aware that sometimes amendments do get introduced at the very last minute. And so you can't really wait on this or have this expectation that you guys are going to consider legislation and there's not going to be any potential for an amendment in between when you guys consider it and the meeting where it's introduced on second reader and that amendment is considered. Because sometimes we do get amendment requests the day of the council meeting.
To be clear, I do not think the mayor has authorized this to be forwarded as Amendment 1. That's my point.
Yeah, but Alderman Thorpe, the problem with that is it's already publicly posted. I know what you're saying and I hear what you're saying, but it's publicly posted.
Do we have a consensus of whether what we've read is, anybody have any major objection to it?
Well, or we can take the discussion we've had and how about each of us put out 1 point or 2 points that we think are important for the council to consider, and then I'll watch the video tomorrow and I'll convert it to a list and send it to each of you so you agree, and then we'll send it to as the recommendations based on what we know so far for this project. Or
so, Mr. Chairman, my only problem is I have only scratched the surface of the contentiousness of this legislation. There are residents, mariners, who are being told that they have an illegal mooring. There are 3 elected officials who do not believe that to be true. And I need to stop talking there.
Okay.
Sorry,
Personally,
John.
personally, I don't have no problem with the way the legislation is written as it stands.
For me, there are certain portions of it that I think are good, and I know they're tough to deal with, but there are things change within a city where you have to enforce it. So that private or not, I don't know if we have an opinion on that. However, I do have an opinion on the distance, and I do trust the harbor masters to make sure the right boat is there, but I want to make sure the code is written in such a way that there is an alleyway or a right of way, not right of way, but there's a distance between a fixed structure of private or publicly owned and the actual swing of the vessel that's being put on that respective mooring. And again, I trust Tyler and Beth to pick the right one, but I'd like it to be sort of written in such a way that made sure there's this protected gap in between. And 75 feet, or it can be modified and adjusted. But I also want to make sure there's logic and reasoning for the harbor masters to deal with scenarios where it does make sense to have some flexibility.
The other question is, I'm getting a little hint of it, is how do you tell these 3 people that what they believe is their property is going to be taken away from them? Then they're going to see what we do by, is it eminent domain? Is this legislation just taking of somebody's, what they consider their property? And I think that's going to be something the council is going to have to figure out. Now, I don't know if they need our opinion on it or not, but I don't think that's in our purview. But I think that's going to be part of the big issue. I mean, these 3 people think their property has been taken from them.
So I don't think the council has to opine on any of that.
Well, yeah, that's how they're going to vote.
There was a house on the corner going into Hillsmere that had horses there when I moved to Annapolis. Someone somewhere from the city, this right by Germantown Elementary School, someone in the city said, when the last horse dies, no more horses allowed on that property. So this is possible for a city to actually say, we're moving a different direction with certain rules. Again, it's happened since I've been here. So I'm sure that the three that unfortunately may not, may have to have some grandfather element that once it's done, I don't know. But let's look at what they did with the horses. But that there should be a mechanism for a city to be able to modify
I
and
mean,
adjust where
at
logical for the
least
general
two
population.
of those three folks have saved over $15,000 in mooring fees.
I'm not worried about
And
the money. I don't think I care more about, are they using helicoils the same way the city does? Do they get inspected? Do they have chain for the right size vessel?
so there's,
Because they're putting everyone else around them
yeah.
at
So there's
at
no way for us to actually legally hold them to some sort of a standard at this moment. There's no way for us to do that. And for us to say that there are 2 or 3 people, 2 of which are not city residents, to have this perceived privilege that's more important for anyone else's like safety of navigability in the city waterways is just, it's not acceptable. That's not okay.
There's what we are doing is there is a taking of what they consider to be their property.
Well, they might consider it to be true, but that is not true.
Well,
It's like if someone said like, "Oh, I've been doing this thing illegally for 30 years, so I get to do it." No, you don't get to do it.
That's not
So,
necessarily true in common law.
well, that's not the common law doesn't apply here.
As to a taking, the city will not be taking anyone's property. The city will be asking them to remove their property, remove their tackle from that area. But
that is a taking.
no, but no one owns the water there. It's not in their they're non-riparian. That's not where they live, and they don't own the water. You can't take that from them, which doesn't belong to them. But we can ask them to move their mooring. That's not a taking.
It might be an issue for the circuit court then. I might go to court.
I don't agree. I don't even think it would even be possible that would go to circuit court.
Okay.
All right, back to, I guess, our recommendations, and again, we can summarize, and then I can submit it to Alderman Thorpe. Are there any other parts of the discussion tonight that any of the port wardens feel are imperative or should be considered as they attempt to revise the first reader or amend? Jonathan?
I mean, I think some clarity on the riparian rights, like what Harold was saying. If riparian rights and mean that person has reasonable use of the water by their property, like a mooring ball might be considered reasonable use. So I think like I don't know, I would need like a lawyer or somebody who's knowledgeable in riparian rights to, you know, provide some guidance here on that element of this legislation.
I think that's one of the things that Alderman Thorpe is going to have to be dealing with.
Yeah.
From what we've been hearing.
So just checking in, I wasn't exactly sure what you said. Jonathan, can you help me understand exactly what you said?
Well, so the riparian rights in Maryland, I mean, there's a whole bunch of case law behind it, and people are entitled to reasonable use of the waterways by their property, and having a mooring ball in their developable waterway, or just some place reasonable where they can use it from their property, might be a protected usage from the state.
100%. It is 100% protected.
But
and so in
Jonathan,
the legislation, if you look at that 100%, it says a riparian property owner has permission to install a mooring ball in there. So there's nothing taking anything away from any person that has a riparian right.
Yeah, and Jonathan, you got to understand, it is enforced. You would have to have an 80-foot wide lot lateral line, okay, plus
Yeah.
80 feet to fit a 40-footer dead center in the middle of your riparian use, because you're not allowed to have a fixed object, which a moored boat, be in a particular area in a fixed manner. So if it protruded over the harbor line or protruded over its setback, it would have to be confined. I don't think that is in our tight city waters an issue that we're tackling.
Yeah, for certain, we would never want to. For certain, we never want to impede on that.
I mean, sounded like you guys were just talking about taking away the mooring balls from these three people. So
These
I don't
folks
know.
They
are
don't
not
live
in.
adjacent or own the area or have riparian rights on the area where the balls are sitting.
Okay. So they just drop them.
Yeah.
Oh, okay.
And possibly with cinder block or rock or mushroom, which is not as strong and safe as what the city requires, which is helicoil chain and appropriate pennant.
So they're
And
also
again, I don't want to
unpermitted, right?
adjudicate this. I don't want to adjudicate
Yeah.
this at the Port Wardens, but I believe it was 2019. One of these people had their mooring inspected and submitted that inspection to the harbor master. So we're working through this.
Okay.
So I just want to protect. I don't want anybody to be improperly disparaged as we have this conversation. That's a real strong interest of the mayor and Alderman Woman O'Neill and myself. So
I understand exactly what you're saying. I understand we've explored every single avenue. However, even if you had it inspected, it's not permitted. And so by allowing that to continue on, we're inviting this liability. And also, the city has a special permission from DNR to allow moorings to get installed. And that has to be, every single mooring has to be specifically permitted by MDE, Army Corps, and the Port Wardens. And none of those have met that. So for us to say, oh, you can do it, no, you can't. We're putting ourselves at peril to lose that permission from DNR to manage our own waterways. So it's a big deal. It's a big deal.
yeah, and thank you, Ms. Bellis. I appreciate that. And we'll work through that. My point is I'm talking about the individuals. We can continue the conversation about the way forward as we work through this. My singular point in this discussion is not about the way to move forward on private or public or annual or transient or riparian mooring buoys. It is to ensure that I protect the interest of the people who are involved as I know it. That's so whether we provide grace periods for people in the future, whether we grandfather, whether we restrict, whether we prohibit, all
Certainly,
that
certainly
is
everyone wants to be
up for
fair.
discussion.
Okay.
Yeah, certainly everyone wants to be fair, but I don't think the perceived privilege of the three individuals is more important than the persons that transit all of those areas to have a safe and navigable waterway. I don't think that their perceived privilege is more important than all of our other persons that may anchor or moor in that area. I don't think so.
All right. We need to. Are there any more recommendations from Port Wardens that we want to just add to a comment, just to give at Alderman Thorpe something. I mean, I think he's thinking about the stuff anyway, and he probably has it intact. I don't want it to go on record that the Port Wardens have made no recommendations. We're just opining because we do have opinions on this. However, we hope it evolves in the appropriate manner. I think at this point, we move to the next issue. And I will summarize some of the points for you, and I'll make sure I submit to the Port Wardens before I send it to you, Alderman Thorpe. Okay. All right. Thank you. All right, you guys might as well stay here anyway. Although I think the next one hopefully is a little bit smoother. And that's 0326. And it's the Annapolis Harbor Lines at Hawkins Cove. Where are we at? All I have is the bundle, so I'm not sure. Is this the first reader or the second reader for this?
It's still on first reader.
Okay. All right. Do you guys have you guys reviewed Hawkins Cove?
Mm-hmm.
All right. We do have a number of public at this. I don't have sort of the formal mechanism because, am I correct? This is certainly not an application. You're just looking for input as to this particular city council amendment or ordinance. Is that correct?
That's correct, Mr. Chair.
Okay. Alderman Thorpe, did you bring this forward, or is there someone from City Council besides you that want to present this in some way, shape, or form, or just summarize?
I'm more than game to more than glad to summarize.
Thank you. Thank you very much. I can share an image if you guys need to.
Just a second before you do. Alderwoman Conti and the mayor are also co-sponsors on this.
Okay.
I want to thank Eric and Ann Rotterer is on as well from Public Works, who have spent a lot of work on this in order to clean up a very important cove there on Spa Creek. So I'll turn it over to Eric and let him explain it. He's been working it, 5 years, 7 years, Eric?
I've gotten more gray.
I'll defer. I'll turn it over to Eric and let him explain it.
Okay. Thank you, Alderman Thorpe. Good evening, Port Wardens. I'm Eric Lashinsky. I'm the Chief of Comprehensive Planning for the city. I'm going to give a brief overview of why this legislation is needed. And it's hard. It will be hard to not evaluate the project itself, but we're here actually just for the legislation. And Ann Roderer from Public Works is the project manager, so she can kind of speak to the specifics of the project. But as the alderman said, and we're also joined by Chris Rager from Balin Engineers, which is the project consulting engineer. As the alderman mentioned, we have been working on this Hawkins Cove restoration and public water access project for several years now, going back to 2021. Prior to that, the Spa Creek Conservancy did a pretty extensive restoration of the upstream tributary to Hawkins Cove that got completed in 2018. And then through funding through Chesapeake Bay Trust and some private funding, we initiated a public engagement process to solicit input on the kind of improvements that would make water access and restoration most impactful to nearby communities to Hawkins Cove. It's a major gap in our public water access network. If you look at the map where people can get to public waterfront areas in the city. It's surprising how much of a gap exists in Eastport in this area. Really between the Truxton Park boat ramp and Burnside Park, which doesn't really have an easy access to the water. There's not much. There's nothing really. So this is a key location strategically to provide that access. It was highlighted in our public water access plan that got adopted by the city council last year. We initiated the formal design process maybe about a year ago, maybe a year and a half ago. It's been submitted to the joint permit process at this point, but we realized through that state-led process, through the Maryland Department of the Environment, that unless we did this legislation to allow for the kind of peer component of this to be legal within the city, we weren't going to be able to advance the application to the public comment period. The fact is the harbor line in this location doesn't allow for the pier to reach deeper water. And the state has very restrictive guidelines on how much of the cove can be dredged. So the design was driven by that. And we're here at this point with this legislation to allow for the harbor line to be modified so that the current design can be advanced to a public comment period that would be led by the Maryland Department of the Environment. And so I guess at this point, Anne, is there anything else you would like to add that I guess you could speak to the exhibits?
Yeah, I just tried to share the exhibit and I don't think did it work?
We're seeing it.
Okay, sorry. It was tiny on my screen. Maybe I'll put on my glasses. But yeah, no, I think that was pretty much correct. So this is basically an enabling legislation to move forward in the permitting and public review process for a project that I'm going to quote the Maritime Advisory Board from last week, a very cool public water access project in Hawkins Cove. So the objective is that the proposed project conforms with existing local land use regulations. In this case, those being the city harbor lines. So our proposal is to amend those harbor lines as illustrated in this exhibit. You can see a cutout basically around the proposed pier extension and floating dock to allow for this public access to reach navigable waters. And the project itself will go through a review process once the public comment period for MDE has completed and the joint permit application is approved. This project will come back. I think the first step in the public review process for the project itself will be to come back to the Port Wardens to dig into the project itself. Sorry, Eric, do you want to say something?
Oh, I think you inadvertently clicked on the image, so it kind of darkened up on the screen. There you go. Yeah.
Sorry.
Mr. Chairman, the other couple other things I would add as we go forward here, again, stressing what both of them have said is this is not the project review process. This is to make MDE requires any possible solution to a problem to be within the legal code of the municipality. So this is a process effort. And then following this MDE, if this is to be approved, MDE, it goes to MDE and they would come back with a recommended way forward. Couple other things just to point out, the Maritime Advisory Board reviewed this last week and recommended moving forward. And to be clear, this has gone through first reader. It has gone through public comments on Monday night. I believe 4 people testified, all in support. The Eastport Civic Association, I believe, has submitted written testimony and testified to the city council that they support moving forward with this. And I think Eric and Ann, I think that covers everything, right?
Okay.
You're
Eric, you're muted.
Yeah, I think we have at least one person that was brought forward that did want to testify tonight.
Yes.
Yeah.
Okay. We love to hear from them before we, again, opine. We're not voting on any element, but yeah, who is that other person? I'm because the image is shared. I'm not seeing all parties.
Sorry, Robert. That's me, Mike Tomasini.
Okay.
I don't need to swear in or anything. Just here.
Not at this point. We're not voting on anything. So no.
Okay. All right. Well, thank you all for hearing us tonight. I'm strongly in favor of this. My name is Mike Tomasini. I'm an Eastport resident, 212 Eastern Avenue. I spend a fair amount of time on the water here in the city, and like Eric said, it is noticeable the gap of water access points that are actually usable on the Eastport side of Spot Creek. And this is a really interesting and great way to provide access to people who just currently don't have it, at least don't have it in an easy walkable format. So for me, I think that this harbor line adjustment is a slam dunk, because it's really just a way to get to the next step of actually coming up with a plan of what is possible, what can we do there, and not getting bogged down in the, well, we can't adjust the harbor line because some people might be opposed, or, this is a first swing at the ball, and we don't get a second swing at the ball if it stops here. So I just strongly urge you all to support this so that it can move forward to the next step.
Okay. All right. As far as questions, and again, you'll hear me in a second. The parking presented in the image, there's that green area, and then it looks like a walkway up to what might be a parking. That's owned by the city, right?
Yeah. In fact, I should have mentioned in the intro comments, but this location is directly behind the Housing Authority offices, and the city's largest public housing community is being redeveloped as a separate project. And so the idea is for this site to really tie into that redevelopment and be sort of a focal point for that.
All right. I guess let me ask if the Port Wardens have any other questions. Before I do that, I do want to say that section 151620 and 151630 4 years ago explicitly add the element of including shoreline notwithstanding available waterway for public access and access for public recreation purpose. That it is sort of our Port Warden's responsibility to do the best we can for that, right? Just as the Port Warden sort of do any other Port Wardens have any questions?
No, that's what I was gonna say. I think it's and the only change to that hashed marked pink line, that's the change in the harbor line in the second drawing. Is that right?
That's correct.
Yeah, it's extending the pier effectively.
Okay.
I think this is. Are there
great.
any other questions from the Port Wardens? And I'm only seeing a few because the shared thing. I assume not. So, in my humble opinion, I always feel the harbor line is sacrosanct, but for public access. I think that it's our sort of responsibility to make sure we're promoting boating and our waterways for everybody, especially where possible, and using the fact that it's effectively public property that allows the great access to that. There's a pure boating side also, that it's super safe down there, so people using smaller vessels, it's like I mean, the wind could be horrific from almost any direction and it's still safe, right? They're also not competing with a whole array of a quadruple boat ramp situation so I almost can't think of a better location for something like this to go in. And again, I know we're not voting on anything at this particular time, but I wonder how the other port wardens feel about how this is a sort of I think a slam dunk to modify the small amount of the harbor line for this.
Slam dunk.
But it's not a vote. I just, discussion.
Looks
Jonathan?
good.
Yeah.
Looks good. Slam dunk.
Yeah. Jared? Harold?
No, I agree.
Okay.
I agree with your comment about changing the harbor lines, but I think, yeah, we have the obligation to do. I agree. I think it's a great project.
Yeah.
Why did it take y'all so long to think of this one, put this one together?
It's here. I think it's great. So, I mean, I don't know if what is needed formally other than the port wardens are fully in support. I would say if I don't want to speak for everybody, we can vote if everyone wants to hear that. But I believe all four of us think this is the exact circumstance when to modify the harbor line.
Could we just do a motion to provide a favorable recommendation?
Yes, that would be great. I'll entertain. Do
Yeah.
you want to make the motion?
I'll make a motion, yeah, for
Okay,
a favorable recommendation.
All right. And can I get a second?
I'll
Jared,
second.
thank you. All right. All those in favor of a favorable recommendation to modify the harbor line in Hawkins Cove for this project? Aye or yes? Aye. All right. That's unanimous. Thank you.
Thank you.
Thank you.
Thanks everybody for presenting too.
Thank you.
And sorry for the long meeting, all of you. Carrie, thanks for hanging in there. Jackie, Mr. Thorpe, and the port wardens, Mike especially. All right, let me get back to what we're supposed to do just to finish out, which is there anything for the good of the order? Good. All right, next regular meeting will be April. I did not write down the newest. What's the next one?
April 28th.
April 28th. I would love there being nothing on the agenda to entertain a motion to adjourn.
Make that motion.
Okay, Harold, thank you. Can I get a second?
Second.
Jonathan, thank you very much. Guys, have a great evening. The meeting is, do we have to take a motion? Oh, good. Please, all those willing to adjourn, please say aye or yes or hell yeah.